Sorry for that. We had a little bit of delay. We're having a hard time getting the streaming onto YouTube going, but we'll continue to record. This is being recorded, and hopefully any online audience members can pick up the broadcast here shortly once YouTube kind of lets us in. But that doesn't affect your viewing experience, hopefully. So we'll go ahead and get underway with this. My name is Blake Bingham. I'm the Assistant State Engineer from the Division of Water Rights, responsible for the water rights adjudication program throughout the state. This is the public meeting for the American Fork South Subdivision of the Utah Lake Jordan River General Water Rights Adjudication. Obviously, you probably received a notice and a letter as well as a summons informing you about this meeting, and I just kind of want to throw it out there, first things first, that you're not obligated to be at this meeting. I know when we send those notices out and that those legal summons, that it can kind of get people a little bit anxious. They believe they're supposed to show up here and defend their rights or all kinds of things. So if at any point during the presentation tonight you feel like your curiosity has been satisfied, feel free to stand right up and make your ways to the door. If you feel like you're running short on time, but you have some specific questions about your specific scenario, again, you can stand up, and I have some staff. You may have already talked to them out in the back, and they'll be able to take your questions and answer your specific questions. If you have a question that's kind of a general nature throughout the presentation, go ahead and raise your hands, and I'll do my best to repeat the question so that those viewing online and as well as in the audience can hear and understand the question and then answer it. If it's more specific to your situation, I might just ask you to hold off until the conclusion of the presentation so that everyone can have the opportunity to listen to it and go home if they want. But I'll stay here as late as the school will let me answering your questions. If we have to move into the parking lot, I can do that too. So I understand it's probably not intuitive what we're doing here tonight. I'm going to try to take you from I recognize there's probably all levels of understanding with regard to what a water right is or a general adjudication. So I'm going to try to get us all caught up onto the same sheet of music. There's a lot of backstory to kind of get us to that point. But here's our agenda for this evening. And before I move any further, you've probably met some of my staff. One of the key people I want you to be aware of is Tamara Prue. She's back here in the corner. She's going to be the team leader for this subdivision. So if you file a claim, it's going to be her team that's going to come out and review that claim with you. She's going to kind of be directing the boots on the ground efforts. And then I have Melissa Reynolds down here in the corner. She's from the Attorney General's office. She actually represents the state engineer during this since it's a legal proceeding. So if you have an attorney or if you are an attorney and you have more specific legalese questions, you can direct those to her. But again, you can ask me and I'll do my best, and she'll either look at me with daggers or give me an approving nod. So that's our agenda. If you're viewing this online, and I'll circle back to this at the conclusion of this presentation, you can email any questions you have, and I'll answer them at the end of this presentation for the benefit of the group as well as for the benefit of posterity, because we're going to post this on our website so you can review it later. If there was something that I touched on that you wanted to come back and look at again, you'll be able to do that. Okay, well, let's get started. As I said, when we have these meetings, we've had them all down the Wasatch Front in the Salt Lake Valley and now into Utah County. Again, there's all levels of experience and understanding of water rights. So we start off generally with kind of a water rights 101, and we start off with, what is a water right? When we send out our notices, one of the first questions we get when people call in, they want to know, well, how do I know if I have a water right? So we're going to talk a little bit about what might be indicators of a water right if you're not sure whether you have one or not. But let's talk about, first of all, what it is. A water right is a specific type of property right. It's not like a traditional property right, like your property, like your house or your yard or anything like that. It's It's a right to use, to divert and use the waters within the state of Utah. And it's typically defined by a couple different elements. First of all, there's a defined nature of beneficial use, and that's essentially what is the water being used for, and we quantify that in the number of those units. So if you're using it for irrigation, it'd be the number of acres of irrigation. If it's for stock watering, the number of head of stock. If it's for your domestic or your culinary purposes, it's how many residential units, okay? There's a priority date, and I'm going to talk a little bit about the concept of priority and what we call the system of prior appropriation that we operate in the West, and specifically Utah. Priority date pretty much it specifies where in the line that water right gets filled. You know, we have a finite amount of water, but we have a lot of demands on that water. So the priority date says, all right, how senior am I compared to my neighbor? Do I get my water before they get theirs? Okay, that's indicated by the priority date or the class of water right associated with it. We have a defined quantity of water, which we measure in two different types of metrics. There's the traditional flow rate, which is a cubic foot per second, or CFS. And then there's more of an annual flow rate, or an annual volumetric limitation, which is an acre foot, annual acre foot. If you can imagine a cubic foot per second, if you say a basketball is about a cubic foot, so one of those basketballs running past you every second is one cubic foot per second. An acre foot is kind of a larger quantification we use. If you imagine a parcel that is an acre in dimension, if there was water 1 foot deep, that would be 1 acre foot. We have a specified point of diversion, and that's just a fancy way of saying where you're going to remove the water from its natural source. So if it's a stream or a river, it's going to be your head gate or your check dam. That's the point of diversion. If it's a well, it's the well that's removing. That's what we consider the point of diversion. In this area, we mostly have a lot of wells. So when we talk about points of diversion, sometimes we'll abbreviate it with the term POD. We're probably referring to a well in this area. Although there probably are some surface rights as well. Now, the last being a kind of facet of a water right is the place of beneficial use, and there's no mystery in that. It's just where is it being used. We do use the public survey system, public land survey system, to kind of identify that. And if you imagine, that's just a big grid cast over the state of Utah, and we can tell by the numbers in the grid where the location of that use is. If you want more information on that, happy to talk to you more about that later. So how do you know if you have a water right? What may be some evidence of a water right? Generally, if you have a well located on your property, there's most likely a water right associated with it. And if there isn't, there probably should be, okay? And that's one of the reasons why we're doing this, is to kind of get an account of that and to ensure that water rights or wells that don't have water rights get brought onto the record. So there is a water right for it. There might be irrigation ditches or head gates. Those are some of the indicators that there's a water right. You can see some of the images there on either side of the slide, left and right. There's a picture of a typical domestic well, kind of a small well that might be associated with one house, okay? And then you see that middle picture is kind of a picture of a head gate, a diversion structure. So let's talk about what a water right is not. First of all, there's often a misconception, and some people will use the term water share and water right interchangeably, although there are very real different concepts associated with them. A water right is the legal right to divert. What happens is then, typically in the old days or even present day, you have water companies that were formed that would get these water rights, and they'd say, we have this much water, and what we're going to do is we're going to give shares of that water to individual shareholders. So the shareholders own shares in the company owns the water right. So they're kind of a little bit different, although they're related in some sense. There's a big distinction. So what we're talking about are water rights. Although that might translate to water users that they have a share in a company that has a water right, but we're not looking at your specific shares, we're looking at the whole tamale, right? All the shares under the water right. And lastly, it's not a connection to your municipal water provider, okay? So if you have water coming through a meter, that's probably delivered from some type of municipality or a public water supplier, and they have the water right, and then they provide that service to you, and you pay a fee. And you're not obligated to defend that water connection. That's really the company's responsibility. You're simply someone who receives the water at a cost. Let's keep on driving on. So when I do these, as I said, I like to kind of break it down to basics and bring it forward. And part of that requires a little bit of a history lesson. So I promise I'll try not to, I won't bore you. It's going to be really brief, but it's important because it provides the context to why you received this summons, why it is a legal proceeding, why we're harassing you guys now, right? I know we all have more important things to do than to be bothered by a mid-level bureaucrat in the middle of summer. I understand. I totally get it and I empathize. But we're going to kind of, to bring you up to speed as to why we're doing this and why it's important, I'm just going to have to kind of run through the state's history really quick, okay? We all know the story about Brigham Young entering the valley, July 23rd, 1847. Right long after that, they diverted the waters of City Creek to kind of soften up the soil so they could plant some crops, okay? They later built their mall there, so. In September 30, 1848, Brigham Young made this statement, and it's kind of become the basis for how waters in the state of Utah are treated. He said, "There shall be no private ownership of the streams that come out of the canyons. These belong to the people, all the people." And that's a basic tenet of water rights law, that the state doesn't own the water. The people, it's really a resource that we share as a community. It's everyone's water. It's a resource, and it's a finite resource. So in order to make sure that that finite resource is managed and delivered equitably, the state, the Division of Water Rights, has that responsibility to make sure that people who have water rights are getting their water, and that that system of priority functions well. Well, between 1847 and 1850, what we now know as the state of Utah wasn't a state of Utah. It actually, went from being a part of Mexico to this kind of quasi-ecclesiastical state of Deseret to the territory of Utah. However, the government of the territory, or whatever you want to call it, obviously remained church-centric. And when I say church, I'm going to refer to the Church of Jesus Christ of Latter-day Saints. Because they're the ones that filled that power vacuum, right? They were the only ones living out here. As a result of that, diversions from the streams were kind of done on a community basis. Brigham Young would send pioneers north and south, and they would go and they would land in an area and start to improve the waterworks, divert water, dig ditches so they could irrigate and build up the community. And so they did that on a communal basis. And that's where the doctrine of priority kind of began its evolution, where they would recognize that there were pioneers that went out there, they established these communities, they did the majority of the work of digging the ditches, putting the water to use, and then they had follow-on settlers. And because they wanted to share and because they were trying to look out for the best interests of the community, they wanted to allow those other settlers, those later settlers, to enjoy some of the fruits of their labor, but they also wanted to recognize that, hey, they put all the labor into this. And so this concept of primary rights and secondary rights kind of evolved out of that process. And then that kind of intermingled with this concept of mining claims, where first in time and first in right. And that's those two systems got together, and that's kind of what we have today. Is we have this concept of priority. We have some that are based on primary rights and secondary rights, and then we have ones that are just based on straight priority date, okay? And this is actually something kind of cool that was exported to other states later on. So Utah was really kind of a pioneer, forgive the unintentional pun, in actually irrigation practices and developing this concept of water rights. As a result of the government being kind of church-centric, disputes were resolved by ecclesiastical leaders, right? So you had bishops' courts for kind of local offenses. And if you disagreed with the bishop had to say, you go to the stake high council, and they'd kind of serve as an appellate court. Right? They had the power to overturn what the bishop said. And then if you didn't like that, you go up to the Quorum of the 12. And so that's just kind of how they operated, because there was no real other systems in place. Well, as we kind of, in 1852, Utah becomes a territory, and the first territorial legislative assembly recognized that that's just an untenable situation. You can't have the church running the government, obviously. And so they passed an act that authorized the county court all control of the timber and all the water rights and everything. So you had to go to the county court if you wanted to settle a dispute about water. But the thing about the county courts is those were elected positions. So if you can imagine with me, those candidates to be county judges would be probably the same bishops and stake presidents. So not a whole lot substantively changed, and really it was only followed in Salt Lake County. Everywhere else throughout the territory, it was largely ignored. Well, in 1877, the United States Congress passed the Desert Land Act, and that was kind of aimed at giving, kind of incentivizing people to come out and homestead the arid West. Some of the consequences of that act through subsequent case law, meaning people went to court and the judge said, well, this is what this law means, is that it severed title from the land and the water. The water was no longer connected to the land as far as being a pertinent. So back east, if you owned a parcel of ground and you had a river running by it, you had an automatic water right. You could divert water from that river, but because back east water was plentiful, right? And they didn't really use irrigation concepts because they relied on natural precipitation. Well, as a result of this, they recognized that, hey, to actually eke a living out of this arid West, you had to have great big tracts of land, a homestead, and you had to, in order to produce enough to make a living. And the only way you could do that is move away from these canyon streams. And so as a result of that, the concept of diverting water over here and using it for land way over there evolved. And a natural result of that was that, hey, water is not really the same as land as far as title goes. And it also delegated authority to the respective territories or states for deciding how water rights played out, how they were administered. And you might think that's kind of a foregone conclusion in this day and age, but back then, you remember, we still had the government land office, the federal government land office, issuing patents for land. You might suspect, well, they should do the same thing for water. Well, in this case, they said, nope, the state or the territory is responsible for administering those types of property rights. In 1880, they kind of came to their senses, realized, hey, having the county courts do this, it's just not working, it's impractical. So what we're going to do is we're going to establish a law that allows county selectmen to kind of act in a quasi-executive judicial fashion to adjudicate water rights. However, again, it was largely ignored. People continue to divert water pretty much based on the direction of their ecclesiastical leadership. If their bishop or the stake president told them to do something, they just do that. They wouldn't bother going to this county selectman, with the exception of Salt Lake County. There are some records of these in the county recorder's office. As a result, confusion continued to exist in spite of the best efforts of both the territorial legislature and the church. And the church continued to administer and decree water rights. An example I usually cite during this presentation is the 1879 High Council decision that divided the waters of the Spanish Fork River. And that is still how that Spanish Fork River is divided, is based on this High Council decision. There have been subsequent decrees that kind of filled in the nooks and crannies, but the High Council pretty much said this company gets this much, this company gets this much, and this company gets this much, and to this day, that's still how it's administered. So let's move into statehood. Well, in 1896, Utah became a state, and there was a real concern among the citizens of Utah that there was kind of a movement afoot to confiscate all the water rights because they weren't really sure how to handle this. Now that they're becoming a state, does the state now own the water rights? And there was actually kind of a movement in the legislature to do that. And so there became kind of a big controversy, and at the end of it, they decided, hey, let's just not deal with it. Let's just punt. But one thing we are going to do is we're going to write into the Utah's Constitution a clause that says, in essence, that, hey, if you have been using water, you can continue to do so. And that's in Article 17, and it continues to exist to this day as part of the Utah's Constitution. It says, all existing rights to the use of any of the waters in this state for any useful or beneficial purpose are hereby recognized and confirmed. And so that kind of developed this concept of being grandfathered in. We sometimes refer to these as diligent rights or diligence claims. The technical or legal term is kind of pre-statutory claims, meaning these claims existed before there was really a law that told people how to appropriate water. In 1897, the Office of the State Engineer was established. That's what we now know as the Division of Water Rights. So the concept of state engineer is kind of more of a historical honorary title than it. Obviously, there are other engineers that work for the state of Utah and the Department of Transportation and other areas. But the state engineer's office is a traditional name for the Division of Water Rights. But the office was really given the task of going out and measuring stream flows and making sure, just kind of getting a sense for what the resources in the state were. If you wanted to appropriate a new water right, in other words, if you wanted to get a new water right, you still had to kind of do the old-fashioned thing and go and staking your claim at the source, as well as filing that at the local post office and the courthouse and the county recorder. In 1902, the United States Reclamation Service was created. Now I'm kind of getting into why we're doing this, okay? So bear with me. We're kind of past the boring stuff. Now we're getting into the meat and potatoes, okay? What we now know as the Bureau of Reclamation was created in 1902. And their idea, as their name kind of implies, is they were given the task of reclaiming the arid West. And they do that by going and building large reservoirs in the West that could then be used to irrigate and reclaim that West, the arid soil, okay? However, the Bureau of Reclamation or Reclamation Service went to the states and said, hey, we have no idea of knowing whether we have the rights or the ability to fill these reservoirs until we know who has water rights already existing. Because the last thing they wanted to do is spend all this money, build this huge dam, and then have no paper water or legal right to fill those reservoirs. And so they told the states, hey, unless you have some type of system or law in place for both identifying the old grandfathered rights, those diligence rights or the pre-statutory claims, as well as appropriating new rights, we're not going to build a project in your state. And of course, everyone wanted, everyone in the Utah state legislature wants a big project because they want to be able to irrigate and develop their land, right? So it's no coincidence that 1 year later, the state of Utah formally adopted rules that governed appropriating water, as well as adjudicating existing rights. Unfortunately, the system that they set up for adjudicating old rights, meaning going out and finding these old rights and bringing on the records, really didn't work. They kind of expected just the courts to figure it out, and they didn't really provide any funding for the courts to be able to do that. And those of you who are familiar with our legal system, you recognize that it's an adversarial system. You got to have a plaintiff bring a complaint and a defendant come in, and they kind of fight it out before a judge. Well, if you simply tell a judge, hey, judge, it's your job to figure out water rights, they don't really know how to do that. The system's not made for that. They need someone to bring it before them. They need to have a suit brought before them. So the system they had as part of this 1903 law really didn't work to determine those old rights. In 1919, the legislature finally figured that out and said, okay, here's what we'll do. Well, we have this office of the state engineer. He's already kind of proficient in making maps and identifying the capacities on these streams. What we'll do is we'll have him go out and map these areas and give people the opportunity to file a claim, and then he'll make a recommendation saying, based on what I see and I map, and based on these claims that have been filed, here's my recommendation to the court, and he'll kind of push the lawsuit through the court, make a recommendation to the court, and then people have an opportunity to disagree with the state engineer and fight it out in court. Again, you have a kind of a plaintiff and defendant type scenario. And so this is largely the format that we follow today, where the state engineer makes a recommendation in the form of what we call a proposed determination. So when you hear that term, proposed determination, just think that's the state engineer's recommendation to the court as to how he thinks the water rights should look in this area, okay? And so in 1919, that's kind of where we start to see these adjudications take off. If I may back up just back to that 1903 date, that law was only applicable to surface waters. They didn't really distinguish groundwater and surface water as being the same water. Well, obviously it is the same water. They influence each other. So in 1935, so up until 1935, you didn't need a water right to drill a well and get water out of the ground. And they finally realized, well, you can drill, if you drill a lot of wells, it can have an influence on people's surface rights. So we better have a system in place so that you need a water right to drill a well. So beginning in 1935, you had to appropriate a water right in order to drill a well. Again, wells that were drilled prior to 1935 were grandfathered in. Again, they're pre-statutory claims. And so those are some of those claims that no one had a record of. People just drilled wells because they could, and there was no record of those wells at all. So prior to that 1903 enactment, water rights kind of fell into 5 different categories. You had those that were decreed by church leaders. Those that were just filed for record at the county or the county or on the court books. Actually, you had those that were decreed by the court. Those are typically resolving water right disputes between limited sets of parties, maybe 2 parties, and the court would simply say, between you and you, this is how your water rights work. What that didn't do is incorporate water right users down the stream or up the stream and saying your water rights with respect to these other people, because they weren't joined as a party to that litigation. So they're kind of limited in scope. You have water rights that are based on simple contracts or agreements between parties. Have a lot of these in Salt Lake Valley, between Salt Lake City and various water users. Then you had those claims that just never manifested themselves on any record, and those are the pre-statutory rights, the diligence claims that we're talking about. So prior to 1903, there wasn't really a system to appropriate water, so those are water rights that we have no record of. We don't know if they exist or what they're doing. Prior to 1935, same thing for wells. If you had a well prior to 1935, you weren't really required to have a water right. And so those are ones we just don't have any record of. As a result of that, there's a couple of issues. First, there was no public record. There certainly wasn't a consolidated public record. You couldn't go to somewhere and say, I'd like to know what type of water rights there is in the severe river drainage or something like that. Those you kind of had to search and search and search, and even then it was probably not very likely that you'd find much. Since there was no record, over-appropriation was pretty rampant and common. There are a lot of cases where the courts decreed more water than the source was actually capable of producing, and so there was kind of obviously a disconnect between the paper water right and the actual wet water, which is problematic. Because of over-appropriation and because rights weren't defined, there was a lot of controversy. And then it had to be settled either through the church or through the courts, really. There was no other way. Well, a few years after the state engineer's office was created in 1901-02, he kind of, and remember, this is before they had their formal water rights law, that said this is how you appropriate a new water right and this is how we will figure out old water rights. This is the observation he made. He said, the definition of existing rights, meaning those grandfathered rights, appears to be of first importance. This is not only necessary to pacify present contention, but to prevent future conflicts and encourage further progress. There can be no safe basis for future work before existing rights are known and made of public record. So the idea was, in 1903, they'd say, all right, great, time out on appropriating new water rights. We're going to adjudicate all the existing water rights. And then once we have a picture of all those that are existing, then we can appropriate new water rights. Well, because the legislature failed to provide the funding and it was just a bad system, they got tired of waiting. So they just started appropriating new water rights and said, oh, the adjudication, they'll catch up, it'll figure out. Well, here we are, 2019, and we're trying to catch up. This court case that we're a part of, the Utah Lake Jordan River general adjudication, has been going on since 1936, if you can believe it. And so we're finally to your neck of the woods. I know you guys are super excited about that. So what is a general stream adjudication? I've thrown that term out a lot, as the name kind of implies. It's a legal action in state district court, okay? It's the adjudication. We're judging the water rights. And really, as I've said before, it was meant to kind of capture some of these pre-statutory rights, but it's also used to kind of figure out the water rights picture as a whole. It binds water users and the state engineer in one legal framework, one civil action. That's the title of code it's governed by, Title 73, Chapter 4, if you ever want to try to figure that out. The first general stream adjudications took place in the 20s, the Sevier, the Weber, and the Virgin River. Remember, in 1919, the legislature finally gave the right tools to the court and to the state engineer in order to do them. So a lot of them started happening. That also happened to coincide with the Great Depression, and so the federal government provided money to do these big efforts, through money and manpower to go out and survey these entire drainages and make recommendations. And so you can see on that map, that multicolored version of Utah there, each of those different shapes or blobs represents a different general adjudication. When I talk about the Utah Lake Jordan River general adjudication, I'm talking about the big purple blob right there, okay? But all of those are general adjudications. Some of them actually got completed. The Weber River drainage got completed back in 1920. Well, that's when it was initiated. The Sevier River one did. And even the Virgin River did, and then they decided, oh, we don't like what happened back in the 20s, so they started it again in 1980 just because the original one was not thorough enough. But you can see all of them, every inch of the state of Utah has some type of water rights adjudication going on. Again, we are primarily concerned with the Utah Lake Jordan River general adjudication. And just some brief history as to why that got started up. You history buffs might recall during the 30s there was a great drought in the United States, especially the western United States. You remember the Dust Bowl and those types of things. And as a result of that, there were a lot of people who were diverting off of the Jordan River without a water right. And Salt Lake City said, hey, state engineer, we have all this illegal use. Will you please adjudicate this so we can figure out what the rights are worth? Unfortunately, at the time, the state engineer was bankrupt because they'd just gotten done with the Weber River, and they didn't, in those days, you had to pay money to file a claim, and that's how the state engineer recouped his expenses and to then move on to the next area. That failed, and so he didn't have money, and so Salt Lake City just said, fine, if your state engineer's not going to do it, we're just going to sue like 5,000 people, or it's probably 1,000 people. We're going to just sue, and they listed like 1,000 people on this suit. After a couple of different legal maneuvering, eventually the court said, hey, Salt Lake City, you have no authority to do that. This belongs under the general adjudication. And that's when it was born in 1936. State legislature provided funding, and we've been doing it ever since, if you can believe it, just at a kind of a really hit and miss, slow rate. Some of you may have been around when we were probably back out here in the 80s taking claims, and even if you lived in Pleasant Grove or American Fork proper over here, in different areas where we did this. And now we've kind of circled back, and I won't get into why that's the case, but we're trying to get through the Utah Lake Jordan River general adjudication over the next couple of years, just to kind of get done with, so that we don't have to, it will stop continuing to languish. All right, so why do we conduct general adjudications? First of all, we want to bring all claims onto the public record. That includes this guy. You remember, he's the one with the pre-statutory right, whether it might be a surface right prior to 1903 or an underground right prior to 1935. We want that right to come onto the record because it may not be. So we want to make sure that we have a record of everything, including these old pre-statutory claims. Also, there's this concept of Federal Reserve water rights. Now, it has nothing to do with the Federal Reserve that prints money, okay? It really has to do with a Supreme Court case that occurred back at the turn of the century. The Fort Belknap Indian Reservation obviously was established, and back in those days, back in the 1900s or late 1800s, early 1900s, the idea was, well, we're going to take these Native Americans and we're going to make them agrarian, and we're going to kind of civilize them and kind of get them to be more like the white people, right? And so you had the Fort Belknap Indian Reservation along the Milk River, and they said, okay, well, if you want us to do this, then we need water to irrigate our crops. Well, at that time, the state engineer, the equivalent of the state engineer in Montana, has said to them, well, I'm sorry, you're out of luck because all of the waters of the Milk River have already been appropriated by these other settlers. So you have no water right. And so you can imagine that the tribes didn't take that very well and thought, well, that's not fair. You put us on this reservation, you expect us to raise crops, and then there's no water for it. So they sued. It went to the the Supreme Court. And the Supreme Court ruled that by virtue of the fact that Congress had taken this land out of the public domain and reserved it, set it aside, that there was an implied water right that had a priority date equal to the reservation, okay? And as a result of that, they said, hey, these tribes have a water right for their basic purposes of the reservation. What that means, we don't know. And no one can tell the federal government or force them to say what that is, but it exists, and this is the priority date. Well, subsequent to that concept of Federal Reserve rights, or something we call the Winters Doctrine, has been applied to other types of federal reservations. Now, obviously in Utah, we have several Native American reservations, but we also have different types of reservations. We have Forest Service reservations. If you can imagine, the entire United States Forest Service, because it's been taken out of the public domain, has a Federal Reserve water right. What that amounts to, we're not sure, right? But we know it exists. Same thing with national parks and national monuments. The problem with Federal Reserve rights, as I kind of hinted at, is that you can't force the federal government to say what they are, because you can't sue the federal government unless they let you sue them, right? They have federal sovereign immunity. Well, there was a senator out of Nevada who said, well, that's a bunch of BS. How can that even be the case? How are we supposed to plan for our future as a state if we have this looming threat of these claims of Federal Reserve rights on these large tracts of federal land, which in the West were significant, right? The state of Utah, I think, is upwards of 70+% owned by the federal government between BLM, Forest Service, national parks. So it's a big deal. And so he co-sponsored a bill called the McCarran Amendment back in 1952, which essentially said, hey, during a water rights general adjudication, the United States waives its federal sovereign immunity. So the United States has to be part of this action. They have to participate. They have to file a claim like everyone else files a claim. And not only that, they are going to be subject to the jurisdiction of the state district court. So it's pretty significant. It's a big deal. So one great benefit of these general adjudications is we tell the federal government, hey, file your claims. And if you don't file your claims, you're out of luck. And they have to file their claims like anyone else. The state engineer has to evaluate those claims and make a recommendation for those claims. Another thing that the general adjudication does is it prevents a multiplicity of suits. We don't want people suing each other everywhere. We just want everyone sues each other in one big, gigantic suit called a general adjudication. We rip the Band-Aid off really fast rather than doing it piecemeal. Okay, this is where it gets a little bit more controversial, and this is kind of where the questions start to come up. And I haven't had any questions yet, but usually what happens is someone asks one question, then the floodgates unleash, and everyone feels more comfortable asking questions. One of the purposes of water rights adjudications, not just in the state of Utah, but throughout the western United States, it's not unique to Utah, is that we have a finite resource. We have a limited amount of water, wet water, but we have a lot bigger demand on that water. We have people waiting in line to get to that wet water. And so when the original law was passed back in 1903, they said, hey, if people fail to use their water, then that goes back, it gets forfeited and goes back to the public for future appropriations. Because if they're not going to use it, we don't want people monopolizing the waters, okay? One of their biggest concerns is you'd have big companies come in and appropriate the entire Provo River and then say, okay, now you've got to come to me to get your water. So they wrote into law that if you kind of a use it or lose it concept. So that if you fail to use your water, now it used to be 5 years, it's now 7 years. So if you don't use your water right for a period of 7 consecutive years, it could be subject to being reverted back to the public. We call that forfeiture or abandonment, okay? And so one of the things that a general adjudication does is we look at water rights and we go and we look at them, and if they haven't been used, if what once was an alfalfa pasture is now a Walmart parking lot, it's no longer being used, we want to get that water right off the record so we're not trying to plan and forecast based on something that isn't being utilized. And that water needs to be utilized by the next junior appropriator. So that's one of the things that general adjudication does. So that's the knee-jerk reaction. You might have heard the state of Utah is here to take our water. And I think that's the biggest misconception of what's really going on, is that water is already being used. If you kind of flip it on its head and say, all right, let's say you have a very senior water right for 100 acres of irrigation, and you stop using that water right, you stop irrigating that pasture. Well, that water doesn't just go into some imaginary bank and get stored up. Someone downstream is using that water. And as the years continue on, those people become reliant on that water. They develop infrastructure. Maybe they build a house based on that water. So you can imagine how disruptive that would be if suddenly I show up 50 years later and say, I am now going to resurrect this 100 acres of irrigation. I'm going to assume my place in the priority schedule and take that water when people have become reliant on that water for 50 years. So that's really the purpose of the statute, to encourage people to use their water rather than hold it or monopolize it or market it or those types of things. It's just really to encourage use. And finally, we want to obtain a final comprehensive decree. When you appropriate a water right, you get a certificate, you file proof on it, you get a certificate. That's prima facie evidence of the water right, meaning, hey, it means unless it's really rebutted, you have a water right. But having a decreed water right is a decreed property right, and that's really kind of the gold standard of a property right, is if it's decreed by a court, then that's a true property right. Up until then, it's always could be called into question to some degree. Okay, so let's talk a little bit about the adjudication process. This is just going to be a thumbnail overview, and then I'm going to do a deep dive into the individual steps, including what your next step is, right? What you're going to see next if you have a water right, if you want to claim. We'll get into the weeds on that. So it's kind of a three-phase process. The first phase is what we're doing here, okay? The petition to start the adjudication actually occurred back in 1936, and it was actually as a result of the court saying, we are going to move this civil case and turn it into a general adjudication. The notice we published in the paper, we've sent you summons in the mail as well. We are publishing summons in the paper, and then we're having the public meeting tonight. So these are all statutory requirements of this process. The next phase will be, and again, I'm going to get into this more in depth, so I'm going to go fast. I'm just going to cover it, is we're going to send out a notice. Those who are claiming a water right will be required to file a claim. So we'll send out the notice as well as a claim that you can simply fill out or simply sign if you have a water right record and send it back. And then we're going to, for people who fail to file a claim on water rights that we have records of, those will go on a list of unclaimed rights and would be subject to being decreed abandoned. So it's really important that if you have a water right to participate, because if you don't participate, you risk losing that water right. Okay, that's kind of the main takeaway. And if you want to participate, our staff will make it happen. I promise you, if you are confused, we will take you by the hand and get you all the way through to filing a claim. We'll help you file your claim. You can file it with us. You can file it with the court if you want. Again, we'll do a little bit deeper dive into these steps. But the big takeaway is if you have a water right, file a claim, okay? So once we publish the list of unclaimed rights, that just gets rid of all the rights that we have a record of where no one filed a claim. That just kind of say, all right, these people have no interest in participating. These rights are going to be decreed abandoned. And they don't get picked up, they don't get sold and used for something else. They just kind of become null and void, meaning you can't divert water against them. The next step is to evaluate those claims. So if you file a claim, Tamara's crew will probably reach out and touch base with you. You put your contact information on the claim, and they'll coordinate a good time to come out for you to show them your well or how you're using your water right, and they'll come out and they'll evaluate their claim. They'll make your recommendation in the form of what we call a state engineer's recommendation, which eventually gets compiled into the proposed determination. There's those magic words, which is in essence the state engineer's official recommendation to the court. People have an opportunity to oppose our recommendation. They have 90 days to file an objection. We'll hold another public meeting, and eventually, ultimately, the court will make a decision with regard to the state engineer's proposed determination, okay? Let's talk a little bit about filing your water user's claim. So this is kind of the next step after this public meeting, okay? So on July 5th, we will be mailing out from our office to the same individuals who received notice tonight, notice to file claims. We will also publish that notice in the paper, in the Daily Herald, if you take that. In that notice, if you are simply a property owner, so one thing that I failed to mention is that we went to the county recorder's office, we got all the property owners' information that's within that subdivision or that boundary that you have received on your notice, and we sent them notice about tonight's meeting. So that's like 7,000 people, and this is how many people showed up. Maybe there's someone watching online. We're going to send out to those same 7,000 and change the next notice to file claims. If they're simply a property owner, we will send them the notice and we'll send them a blank claim. If they are an owner on our water rights database, meaning they filed a diligence claim already or they filed an application to appropriate and have perfected it, we will send them the same notice, but then we'll send them a water user's claim that's already filled out. All they need to do is sign and send it back, okay? Again, we're trying to make it easy as possible. And if there's any questions, the blank claim is a little bit more challenging because there's a lot of fields in there that are probably not intuitive to people who are not familiar with some of the terminology. So if you want to file a claim and you have this blank claim form in front of you, call us up or come in and we'll sit down and we'll walk you through the process and we'll help you fill it out. You'll file those claims. You have 90 days from when that notice is sent. So July 5th, I think the 90 days gets us to around October 3rd, okay? So you have 90 days to file that claim with either us, with the state engineer's office, or with the Third District Court. The information will be on the claim form itself. If you need more time, you can simply shoot me an email and say, I need more time to file a claim, and we're required by statute to give you an additional 30 days. The only thing is you have to make that request within that initial 90-day time frame. You can't run out of time and then ask me for an extension. It has to be prior to the conclusion of that time frame. It's important to remember that if you fail to file a claim, then you're out of luck. It's really hard to come back from that. So if you want to file a claim, please do so. Yes, ma'am.
Okay, so you said that water rights and owning water shares are not the same thing. So if we own some water shares within the water district, do we not file a claim?
That's a great question. Let me repeat it for the benefit of the audience. So she's a shareholder in an irrigation company or a water company, and she keyed on the fact that I said, hey, it's completely different, and she wondered, well, if I'm a shareholder, do I need to file a claim? My answer is No, but it can't hurt. We really encourage shareholders to make sure that the company is participating. We know that some companies, like the company I'm a part of up in Huntsville, that it's ran out of the glove box of an old Chevy truck. Like, they don't have the resources to understand this type of thing. And so it behooves those who are shareholders to ensure that the company is participating. And if the company's just not participating, then file a claim, and then that will protect the company's right. So if you feel like that's where you're at, if you want to know whether the company's already filed a claim, give us a call and we'll say, oh, they've already filed a claim. You don't really need to. So really, as a shareholder, the only benefit of filing a claim is protecting the company's water right. If you feel like the company's just not awake or not participating, that could be something you contemplate doing. Yes?
So if it's the American Fork Irrigation Company, you could tell us if they've done their due diligence and...
Yeah, so our question is the American Fork Irrigation Company, if that's you're a shareholder in that, we can tell you if they've done their due diligence. Now, I believe the American Fork Irrigation Company was already adjudicated in a previous area. So they may, depending on where they divert their water out, which I presume is the American Fork River, right? I presume that's where their main source of supply is. Probably not going to be adjudicated in this subdivision. I think they are already, but you can call up and ask us, and we'll get you the definitive answer for that. So my understanding, I believe, is that they probably have already filed a claim in their previous adjudication, so they're not at risk to this. But if you have any uncertainty, call us up, and we can find that out for you. Okay. All right. Oh, yes, sir.
So I've gone through that process. I actually spoke with one of your water rights individuals up there. American Fork Irrigation is on the list, but it does not show a prior filing according to your list.
Okay. Okay, so it sounds like...
They have not only surface rights, but groundwater rights.
Okay.
And we need to know, I guess that, I was told that we should probably still file in behalf of our water share. Now, am I being given this information, or what?
I don't think the information you've given differs from what I just said. I recommended, if you're concerned whether the company is participating, that you go ahead and file that claim as a shareholder. And so he brings up the point, for those of you that maybe didn't hear, that the American Fork Irrigation Company has more than just surface sources. They also have underground sources, and maybe one of those wells is within our boundary, and one of those water rights is subject to this adjudication. In that case, yeah, I would encourage you to first, this is kind of like the sequence I would encourage you to pursue. First, talk to the board of the company and say, file a claim on this water right. Second is, if they're just unresponsive or you're just too nervous and the deadline is approaching, file a claim as a shareholder. That's fine too. Yes, sir.
I have a second question, because we're employing also with American Fork City. Because about 10 years ago, 8 to 10 years ago, we allowed American Fork City to use our water shares in means of getting a transmission through their secondary irrigation lines. They're not metered. So proofing based on an acre feet or CFS becomes very difficult for us, and it also puts us in jeopardy of beneficial use.
So that's a great point. So he brings up the concept that American Fork, American Fork, the city, has shares in American Fork Irrigation Company. Is that what I wanted to understand? But do they own shares in the company? Okay. So those shares, what we do when we look at public water suppliers, so American Fork City is most likely a public water supplier because they're a public city. Yeah, so the great thing about public water suppliers, municipalities, is they have better lobbyists than irrigation companies. And so a few years back, they got it passed into law that they are not subject to forfeiture. And so when we see shares owned by a public water supplier, such as Spanish Fork City, we just assume that part of the water right is secured, no need to evaluate beneficial use against those shares. But we're going to look for the shares that are owned by the private entities, just to flesh out to see how much. But Spanish Fork has already been through this process. Spanish Fork Irrigation Company's already been through this process. One of the things that we do is if it's already been captured in an existing proposed determination, we pretty much just take what has already been captured and put it in the new one. There's not a whole lot of analysis. This kind of follows this res judicata concept in legal terms, is that you can't have two bites at the apple. So the state engineer already had his bite at the American Fork Irrigation Company. And so for all intents and purposes, with the exception of possibly an abandoning a right, they can still do that if they don't file a claim on that right. For all intents and purposes, I don't anticipate there being a whole lot of evaluation going on against the American Fork Irrigation Company's beneficial use. I think what we'd probably do is look at what's already been evaluated and recommended to the court and just copy it over. Okay.
We have that on recording, right?
Subject to change. That's also on recording now, so gotcha. That's honestly, I've had this discussion with plenty of attorneys from Central, all over, from Salt Lake City. We're following the same procedure where if you have a right already published in a book, we're simply going to take that right. If it's going to be copied in. Now, this well water right wasn't in the previous book, so there may be a component of that. We just have to look at it. But if the water is being beneficially used or preserved by a public water supplier, there should be no risk. I mean, we're going to do everything we can to make sure that the water user is taken care of. We have there's no benefit to us to forfeit water rights. We want to make sure, all we want to do is, hey, if you're using water, when we come out, make sure you're using it. So we're not going to do the water rights CSI and look back 7 years. If we go out there and see water is being used, we don't really spend a whole lot of time investigating whether, in fact, it was recently put back to use. So, all right. Once we receive those water users' claims, we will, again, as I said, make an investigation of the claim. This is really just to kind of keep the honest people honest, right? And to make sure we understand what our recommendation is going to be. We've had instances where people have claimed, oh, yes, I have a well and use, but it's under my driveway. But the well is there. And so we just try to make sure that, in fact, what's being claimed is actually being used, so that we can make a recommendation in good faith. Let's talk a little bit about the list of unclaimed rights. I'm sorry, this will be online. This entire presentation will be online tomorrow as well, so you can access the PDF tomorrow on this if I scrolled too fast before you took a picture. So you recall, back at the Division of Water Rights, we have an entire room that has nothing but file jackets full of water rights for water rights throughout all the state. These are what we call water rights of record, meaning we know these numbers, we know where they're at, what's being diverted. So when we talk about the list of unclaimed rights, we're only talking about those water rights that are on our records for which no claim has been filed in this area, okay? So for instance, if you have a well and you appropriated it in 1945 and perfected it, that would be on our records. And if you failed to file a claim on it, then we would take that water right number and we would put it on this list of unclaimed rights. And we would send out notice to the same individuals who received notice about this meeting tonight. And we'd say, hey, this list is published. Look through this list. Hold a public meeting. And then people have 90 days from when we send notice of that list of unclaimed rights to file an objection and a water user's claim. So if a water right appears on this list and you don't want it to be abandoned and it's yours, you'll need to file an objection as well as a water user's claim at that time within the 90-day time frame. But those have to be filed at the court. Since now it is a legal proceeding, an objection is a legal motion, it's a pleading, that has to be filed with the court, but you also have to send a copy to the state engineer so that we have it on our records. We traditionally don't challenge these. You just have to provide a reason why you failed to file a claim within the 90-day window. And there's all kinds of reasons. Just make sure you pick a viable one. Again, if it's some outlandish reason, we might object and we might litigate it. But for the most part, we're not in the business of playing gotcha, right? It's not, we don't play stump the chump. We try to just hey, if you failed, we get it, let's drive on, bring your claim and we'll evaluate it later. So we don't do a lot of litigating against these types of objections. And hopefully the court will accept the motion and will acknowledge the claim was filed in good faith, and then we move on to our next step. Those rights that remain on the list of unclaimed rights, if there's no objection to them, the court will then issue a decree that says that those rights have been abandoned. By virtue of the fact that the people who own those rights failed to participate and showed no interest in the process, the court then enters a decree saying those are abandoned. For the most part, those are rights, again, are the pasture that is now a Walmart parking lot, and the people who own them say, well, why would I participate? Because the state engineer is not going to recognize them anyways. I may as well just do nothing and get on with my life, and they become decreed abandoned. Another aspect of this decree is that it will close the area to future diligence claims. So you recall those pre-statutory rights. Up until this decree, you could have filed a claim, on one of those rights saying, hey, my great-great-grandfather diverted water out of this river or this well. We've been using it ever since, and you would have been grandfathered in. After that decree, that essentially said you had your opportunity to come forward and file a claim on that right. Therefore, the state engineer won't even look at those diligence claim filings in the future. So it essentially closes the area. So let's talk about the proposed determination, which is, again, the state engineer's official recommendation to the court. We take those claims, we evaluate them, we come up with our recommendation. We will mail our recommendation before the proposed determination to the water user so they know where we're going with it and give them an opportunity to say, no, you have it wrong, this is really where it is. But ultimately, we take those recommendations, we compile them into this one book called the proposed determination. We send out notice, we file it with the court and then send out notice to people who have actively participated in the process. So the 3 previous notices went to everybody, all 7,000 and change. This notice only gets sent to people who file a claim or who enter an appearance, who are legal counsel to those who have filed a claim. So you receive notice of the proposed determination, we'll hold a public meeting. Again, you have 90 days. If you don't like what the state engineer has to say in the proposed determination, if you think we got the quantification wrong or any other component of it wrong, or if you don't like, if you disagree with our evaluation that you haven't used the right in last 7 years, you have the obligation to file an objection. But you only have 90 days to do so. Again, that objection needs to be filed with the court. We run the gamut of options. Some we say, oh, it's a clerical error, our mistake. We'll agree with the objection and ask the court to revise the proposed determination. The middle ground would be kind of a settlement negotiation process where we sit down with the water user. They say, hey, water user tells the state engineer, hey, you gave us 10 acres. We really have 50 acres. The state engineer kind of we scratch our head and said, well, I don't really see 50 acres, but I guess if I kind of close one eye and squint at it really hard, I can see 15 acres. And then we enter into a stipulated settlement agreement saying, okay, it's really 15 acres, and we petition the court to change the recommendation. And then there are those that we just don't agree at all, and we litigate those. And that means you get a lawyer, we get a lawyer, and we see each other in court before the special master, who is you have Judge Laura Scott, who presides over the entire adjudication. Then you have what's this kind of lower judge called a special master, who presides over the objection resolution process, and we litigate it. And we let the court decide whether the state engineer made the right recommendation or not. Eventually, once those objections are resolved, we petition the court to enter an interlocutory decree. It's interlocutory, meaning partial, in the sense that we're only decreeing one bite-sized piece of the entire adjudication. So the entire Utah Lake General adjudication, Utah Lake Jordan River General adjudication, we are only asking for a decree on the American Fork South bite-sized piece. So here's a kind of you have this same map on your handout, kind of. All those pink dots represent points of diversion. For the most part, these are wells. There are some service points of diversion. We have record of about 724 water rights of record that we know of in this area. Usually what happens is through this process, we find out that there are more water rights. People file a claim on a water right that wasn't previously on the record. Most of the rights are underground. We sent out notice. I guess it's this 6,700, not 7,000. That's the number of people we've sent notice out to. Okay, issues and anticipated timeline. First of all, there's a lot of you recall those water rights that we have on our records back at the Division of Water Rights. A lot of those were appropriated many years ago, and property has since changed hands. So the person who filed the original appropriation and got the water right in their name has since either moved or died, and that property now belongs in the name of somebody else. However, although the county recorder's office updates title to the ownership of the property and keeps those records current, they don't link up or sync with our water rights database. And so we have no way of knowing who the owner of the water right is, even though the county recorder suggests that this person is now the owner of this parcel. One thing about water rights is they are considered appurtenant to the property upon which they are used or reside upon, unless they are explicitly withheld when the deed is conveyed. So if I have an acre lot, I have a well that irrigates that acre lot, when I sell that acre lot, it's presumed that that irrigation went with it, unless I explicitly in my deed withhold that and say, I am conveying interest to the parcel, but I am accepting the water right. Usually what happens, though, is they're just either silent or there's a boilerplate transmittal conveyance of ownership of any water rights, mineral rights. You've seen those kind of boilerplate examples. So typically, the bottom line is that the water right is probably in your name. However, in our records, or let me rephrase that. The water right, you are probably the owner of that water right, but our records don't reflect that, and that's problematic. Yes, sir?
My father had acreage. They put a well in. Just before he died, he put it into an LLC.
He put the water right or the land? Okay. That's exactly where I'm going. So in his example, his father, before his death, put his property into an LLC. It had a water right on the property. However, when we sent the notice, it was still addressed to his father because our records haven't updated to reflect that the ownership is now in this LLC or this trust, okay? And his question is, what do we need to do? What are we concerned with? We encourage people to update title with our office. It's a separate process. It's called a report of conveyance, okay? And you have to do it. A water rights professional has to do that for you, okay? But you don't have to do that to participate in this process, meaning you can file a claim as a claimant saying, we recognize this water right of record is in my father's name. I'm still going to file a claim on it and claim it, and we'll just preserve it. But it will continue to be in the name of the previous owner until you update title to it. Did you have a follow-on question to that? You do it at our office. So again, the county has record that the LLC is now the owner of that property, but our office on the water rights side of the equation doesn't have records that show that conveyance has occurred. It's in Salt Lake City. So the corner of Redwood Road and North Temple. It's at the Department of Natural Resources. At the conclusion of this presentation, I'll have our address. You can come in, but there's a process called a report of conveyance. You would either need an engineer, a surveyor, an attorney, or a title professional to do that conveyance, that water rights conveyance. They're considered trained in order to understand whether that water right has in fact followed the conveyance associated with the parcel. So But there's a whole separate process. Again, that's not necessary to participate in this. You can still act as a claimant and move forward, but we encourage people, again, to avoid the notices going out to the wrong address and just to get your stuff updated, because one of the challenges is if you ever wanted to renovate that well, in order to renovate a well, you have to get approval from the state engineer's office to ensure that you are the owner of the well. Well, if you submit a well renovation request, they're going to look at your name on the request, and they're going to look at the owner's name of the water right and say, hey, you're not the owner of this well, so we can't process this request. So you want to make sure that that's updated, so that if you have any type of maintenance on the well needed, that you're able to do it, okay? It's just a measure to ensure that people are only doing maintenance on their wells. And that's really what sets a safeguard. I mean, people could say, oh, I'm chafing against this government overreach, but really it's just to make sure that your neighbor is not tampering with your well. We just want to make sure that's the case. Another issue is this concept of no proof required. So back in the 30s and 40s, mostly the 40s, during World War II, there was a lack of water rights professionals, engineers and surveyors. And because of that, so to kind of back up, if you were to appropriate a new water right, part of that is you have to show that you've put that water right to use in a certain amount of time. And you do that by filing a proof. And a proof has to be filed by a surveyor or an engineer who can map it and show that, yes, you are in fact using this well. This is the location of the well, and this is the location in the map of where the water is being put to use. Well, because all those professionals were, in Germany fighting Nazis or in the Pacific fighting the Japanese, there just wasn't a lot around. And so the legislature created a law that said, hey, if you're only diverting a small amount of water, you don't need to file a proof, which was great and very appropriate, right? It was easy. It helped people who were just drilling a well for their house to just move on without having to worry about trying to track down an engineer. The problem with that is that, when they appropriated those water rights, they pretty much just used a big USGS quadrangle map, right? And said, this is the location of my well. And it was kind of roughed in. And not being an expert, they kind of estimated that. As a result of that, of there not being a subsequent proof saying, no, this is the exact location of that well, the locations on these types of water rights are sometimes wrong. And I'm going to show you a map interface that kind of shows you saw that previous map, right? All those dots. Well, if you look at that, there's a lot of, you can almost discern a grid on that. And that's because people say, oh, it's pretty close to this section corner. So they didn't file proof. So the location of those points are probably approximated to some extent, okay? As a result of that, when you're trying to figure out what water right is yours, if you don't know what water right number, and I'll show you a way to kind of help discern that, you might say, well, my well's, in my backyard, but when I look at this aerial imagery, you have a well that's over in my neighbor's yard or in the middle of the street. How can that be the case? It's because potentially it just was never proved up on. There was never a correction made by the engineer. Or it could just be a problem with our GIS referencing compared to a surveyed point. There are lots of problems, but on the bottom line is when you see a point on our map, take it with a grain of salt. Yes, sir?
So I want to step back just a second. When you were answering this gentleman's question, you said that, and I'm paraphrasing here, that a claimant form should be filled out by a surveyor, a lawyer, or someone to that.
No, that is not what I said.
It doesn't apply to the claimant form, correct?
Yes, that's a good clarification. Proof or report of conveyance, okay? So his question is, he made reference to something I said earlier about a professional having to fill out a certain type of form. That is not the claim that I'm talking about. So when you receive a water user's claim, you don't need a professional to file that. You just file that, and you file it free of charge. And again, if you come to us, we will help you file it. We will help you understand what those fields mean. The forms that I was referring to are either the report of conveyance, which is something used to update title to your water right, or a proof form, which is something that's not really addressed in the adjudication. That's something different. Thank you for that clarification. Okay, anticipated timeline we already talked about. July 5th is when we're going to mail out the notice to file claims, so you can, and that's a Friday, I believe. So maybe the following Monday, Tuesday, be looking for those notices in your mailbox. That's July 5th is when the 90-day begins. It begins from when the claim was mailed, and that's according to the statute. October 3rd, I believe, is 90 days subsequent to July 5th. That's when that 90-day window will expire, so you want to make sure you have filed your claim by then, unless you've requested an extension, and then you have another 30 days on top of that. Sometime January 2020 is when we hope to publish the list of unclaimed rights. The 90 days after that is around April 2020. That's when when we publish that list of unclaimed rights, you'll have 90 days to object to it. So around April, sometime in April, that objection window will conclude. And then around August 2021, we've actually entered an agreement and filed it with the court, filed a motion in the court saying we're going to delay the publication of the proposed determination until no earlier than August of 2021. The reason behind that is because we're going to continue to do these subdivisions and kind of chase it up the Provo River. And on the Provo River, there are some very complicated and complex decreed rights. And we just want to make sure that we have an opportunity to go through the entire drainage and treat all those rights equitably. And it's not as big a deal here because a lot of these water rights are very straightforward. But as you got into surface rights, they become more complex in how they interplay with each other, especially in the Heber area versus the Provo area. So we've essentially said, we are going to defer actually publishing this proposed determination until we've had a chance to look at all of them so that we treat everyone the same. One of the advantages is that if you file a claim within that initial 90 days, you can always have an opportunity to amend that claim later on, even after that 90 days. You just have to file in that 90-day time frame. So that's one of the benefits to the water users is that if you think you filed a claim wrong, you have time to amend it up until we file the proposed determination. Probably not going to be as big a deal for most water users. It's more of a bigger issue with municipalities and water conservancy districts who are trying to really file a claim or trying to understand their decreed rights, which can be kind of ambiguous, and draft a claim to make it satisfactory, and that might take different forms. So it's really kind of meant to help people with very difficult, complex, ambiguous rights to kind of refine their claim later on. And then, again, we'll have 90 days to object to that proposed determination. So assuming that we publish the proposed determination in August of 2021, that would put that 90-day period concluding in November of 2021. Okay. So here's the kind of one of the last slides. This is kind of the question most people have on their minds when I give this presentation is, will I lose my water right? The answer is water users who are currently using their water right within conformance of the records on division really have nothing to worry about as long as they file their claim within the prescribed time frame. Those who are, oh yeah, sorry. No problem. That's a great question. Thanks for bringing that up. So let's talk about, this question is, what's the likelihood we're going to be shaving down your water, right? Reducing it, right? Is that kind of what you're asking? So we've talked about forfeiture, this concept of forfeiture, that if you're not using your water right within 7 years, it's subject to being recommended to the court that it be disallowed or forfeited. There's also this concept of partial forfeiture, meaning if you have a water right for 100 acres of irrigation, and you're only irrigating 50 acres of that, when we make our recommendation, we're going to make our recommendation for 50 acres, so you can get pared down if you're not using your water right to its greatest extent of its beneficial use. So that's something we call partial forfeiture. Okay. So there is a likelihood if you're not using your water right to its greatest extent. And really, it just means, hey, within the last 7 years, you have to have used that water to its greatest extent. It doesn't mean you have to do it every year, but within the last 7 years, at least once. And it doesn't apply for water rights where the water is not hydrologically available. Let's talk about water rights that have kind of a lower priority date, a junior priority date, and maybe they're on streams that in dry years don't provide enough water to satisfy that water right. The law says you can't use that as a basis for forfeiture. It's only if people are willfully, if the water is available and they're just simply not using it, okay? So it's not if you have a dry year and you can't get the water. Yes? Certainly.
So, if I heard that right, if we have access to water and we are not using it to the greatest extent that we can, it is very likely that we will be asked, or that we will have to forfeit a portion of that right. Is that correct?
Yes, that summary is correct, but I want to make sure you said it in a way that makes me a little curious if maybe but yeah, no, I know you. So the way he phrased it is if you have access to water, you must use that water to the fullest extent possible, otherwise you risk forfeiting part of that right. And I would say, let's rephrase that. If you have a water right, not simply if you have access to water, simply if you have access to water does not guarantee you a water right, okay? If you've been using water prior to 1903, you have a claim to a water right. If you've been using water prior to 1935, you could have a water right. Or if you've appropriated a water right subsequent to that, then you should be using water to that greatest extent. Now, if you moved into your house and just started taking water out of a ditch, that doesn't constitute a water right. Simply because you have access to it does not a water right make, okay? So that's why I just wanted to correct. Does that make sense? The second bullet point, if you have a water right if you're using water without a water right of record, again, if you have one of these pre-statutory rights, you need to participate or otherwise you'll be barred from making that claim in the future. Once the list of unclaimed rights is decreed, the judge closes the area to any more claims, okay? So now is your opportunity to participate. And if I miss a hand, just wave it vigorously. The spotlight's kind of hard for me to see. Let me see. If the water use authorized under the water rights has fallen out of use for 7 years or more, water right or a portion thereof may be recommended to be sought. Again, we covered that, okay? So this is pretty much saying the same thing 3 different ways. But the bottom line is if you have a water right, use it to its fullest extent. If you haven't been using it to its fullest extent, when we come out to look at it, make sure it's being used to its fullest extent, okay? Again, what's up? Oh, yes, sir.
Sorry, you may have already answered, so I came a little late, so I don't know, but just for those that are living in recently developed homes that are receiving pressurized irrigation, do they need to file a claim for that?
So his question is if you're living in a new development, a new subdivision, they're receiving pressurized irrigation, do you have to file a claim? My answer is probably not. That pressurized irrigation, and I'm not sure of the particular situation, may either be provided by the municipality or it's provided by American Fork Irrigation Company or some other water company. And those entities are the ones responsible for filing a claim to protect that water right. Honestly, municipalities are all over this. Like, you don't need to go tell American Fork City, hey, make sure you're participating in this general adjudication. I hear from them more than I want to be quite honest with you. So they're well involved. Irrigation companies, it's kind of hit and miss depending on the size and how robust the irrigation company is. Some are much more sophisticated, have attorneys filing their claims for them, and others, again, are like mine that I'm part of. There's a bunch of residents trying to make the company work, all right? But again, if you have questions, come talk to us, give us a call, and we'll answer it for you. Did I answer your question for you? Okay. Who can I contact to discuss this? That's me at the top. My deputy, Gary Brimley, is actually on vacation in St. George this week, but that's his email. But really, the person who you're going to get the best answer from is going to be Tamara Prue or one of her teammates, okay? So that's why I put her phone number there. I omitted mine. give her a call. And if you can't get through to her, leave a message and she'll return your phone call, or send her an email address. That's our physical address of our office down there, 1594 West North Temple. In essence, it's on the corner of Redwood Road and North Temple in Salt Lake City. Okay, I'm going to look at my email. Again, for those of you who are joining us online, if you have a question, you may have missed this slide early on, you can send a question to this email address. And as well, that goes to anyone here if you want to send a generic question. This email just goes to my inbox. But if there's someone online that has a question, they want to send it to me, I'm going to check my email and see if anyone has actually sent anything. I don't see anything populating. Are there any other questions from the group? Yes, ma'am. Yeah, so if you go to, you see that waterrights.utah.gov, I'll show you how, I'm going to get on the computer here and kind of take you through some of the interfaces we have available online. But yeah, this presentation will be put in a PDF and put under the public meeting. So this public meeting has already been advertised on our website, so it's going to be under the same. I'll show you how to get that, but yes. Long answer for a short question. Yes?
Was that timeline
Specific to this subdivision. 5. Triple nickel.
So if I own water at 55-2,
Yeah, 55-2 has already been adjudicated. Like, they've already gone through this entire timeline. No, so we're still working on objections in that, and so we have not issued a decree, believe it or not. We've just had some really sticky wickets in there. We may have to do an addendum to the proposed determination, meaning we've missed some water rights, but we have not issued a decree. If we publish an addendum and you're a water right owner of record, you'll get notice of that addendum. But for the most part, if your water right was published in that book and no one's challenged it, or you haven't challenged it by an objection, ultimately it will get decreed as it is constituted in that book. Okay.
this question is a little bit specific, but I'll ask you.
Go for it.
So if the 55-2, if it goes through to a decree, even if the deed record of ownership doesn't match the decree, because the decree is considered, that's what it is.
That's a really great question, actually. Interesting. But so our question is, if, let's say, this book or any other book gets published and ultimately gets decreed, but it's in an old name, old owner of the water right, and that person's name gets decreed, is that the new owner, even though, they're no longer really the owner? Typically what we do is in the decree or in the preamble to the proposed determination, we tell the court that the proposed determination does not quiet title, that the title to the water rights is still subject to the respective deeds and other conveyances. So even if it is decreed in that name, you can still update title to it so it can be in your name. It's just decreeing the validity of the water right itself, not the title. Okay. But yeah, it's a very good question and kind of very nuanced. So I'm going to kind of break from the presentation. Oh, sorry. Oh, yes. No, you're fine. Just fine.
So with the water rights, any water rights that are relinquished, forfeited, shaved off, however that goes, those are going back into the pool where it's then Utah that owns them?
Yeah, it's a great question. So,
And I'm sorry, the second part to that. Then does Utah then take those rights and then resell them out to other people?
great question. So this question had to do with forfeited or abandoned or maybe partially forfeited rights. What happens to those rights? Do those go back into the pool, and then does the state of Utah now own them and then sell them to someone else? The answer is No, they simply go away. The thing to remember is that a water right that hasn't been being used, remember my example of the 100 acres of water that I had that I haven't been used for 50 years. The fact of the matter is that water is already being used. And you got to remember that in this area, we have this much wet water, but this much paper water. So if we remove one of the stacks of paper water, it just means the next in line gets a taste of wet water. And so that water right that we remove from abandonment or forfeiture, it just becomes void. We don't sell it. The theory was that if you had more water than paper water, then we take that out, and that's that much more water that can be appropriated. But currently, we're over-appropriated. So really what it means is you can't really appropriate that water. It just ensures that the paper water matches the wet water, that people who are already using the water have a assured basis that they can continue to use that water, because now that right that's no longer being used is removed off the record. It's become void. Utah doesn't own them any more than we own them now. We don't sell them. First of all, we don't sell water rights in the first place. We simply govern the appropriation of those water rights. So it doesn't go in anyone's pocket at all. All it does is ensure that those who have been getting wet water because someone has not been using their water can continue to do so and can rely upon that. It's kind of a counterintuitive concept. It's kind of hard. So if it's a little fuzzy, I don't blame you. Yeah. Yes, sir.
There's a finite amount of water. Where are the developers getting all this? Don't they have to procure these developers a certain amount of water rights before they can develop big subdivisions and whatnot?
So his question is, he called me out. Hey, you said there's a finite amount of water. Where are all these developers getting their water? I want to make it clear. There's a finite amount of actual physical wet water, like physical water that you can drink and what. There's a limited resource. There's plenty of paper water out there. There's probably more than double the amount of paper water than wet water. So the question is, where are these developers getting their water rights from? Well, when we talk about water rights, we're talking about paper water, right? And so, and really you got wet water, and then you have paper water. And I use that saying that, you have all this senior water rights. And so people are taking these. So what usually happens, how developers get water, is that farmers get tired of growing alfalfa and decide to grow houses instead. And so they take their irrigation rights, or their shares maybe in some cases, and sell them to developers who then take that water, go to the respective municipalities, say, we want to develop this into a bunch of houses. Here is your paper water so that you can divert more of that water. So it's really saying, hey, this water that was once being used to irrigate alfalfa is now being taken and put into the municipality's culinary system to satisfy the demands of those homes. So that's where the water's coming from. It's kind of, they dry up irrigation and grow houses. And it's almost a one-for-one. A quarter acre of irrigation can get you pretty much a domestic unit.
So it is legal then to sell your water?
Absolutely, yes, it is legal to sell your water. Matter of fact, you can go to ksl.com and find people selling water, buying water. You can go there. I think there's some other Utah Water Rights Exchange.com. Has nothing to do with me and us or this process. So just put that out there. But the free market exchange of water is alive and well. People have become millionaires off of it. Yes, sir.
So correct me if I'm not wrong, there's a difference between agricultural use water and municipal and industrial. I think this guy brings up a very valid question. How do they convert that from agricultural uses to municipal and industrial?
Okay, so this question has to do with how do you get irrigation water. There's a difference. When I first started off this meeting, I talked about that each water right has a nature of beneficial use. And so when I talk about irrigation water, I'm talking about agricultural uses, right? And the question he points out is like, you talk about these developers getting this irrigation water and then somehow turning it magically into municipal water. I thought you couldn't do that. You can do that. It's via something called a change application. So if you say, I've been using let's just keep the number simple, right? 10 acre feet for irrigation, which gets you like 2.5 acres worth of irrigation, okay? I've been using this 10 acre feet to irrigation. I want to take that 10 acre feet and I want to turn it into a municipal water right or domestic use. So we say, all right, this 10 acre feet was about 2.5 acres of irrigation based on the duty value, 10 acre feet. That will get you about 20 residential units. Probably closer to 10 residential units because we look at the depletion to determine how much water so that there's no net deficit made by this change, that the amount of water being consumed under irrigation stays the same even though the use has changed. We want to keep it balanced. And so what will happen, developers will buy large swaths of land, get the water rights associated with them, and they will file a change application, and the city will file a joint change application and say, we will buy this water if the state engineer approves the change application. And that's part of the negotiation they have with the city to make sure that because the last thing the city wants to do is buy a water right that's going to suddenly be forfeited, right? Because then they've just paid out a lot of money for something that has no value to them. So usually what they do is they condition the sale based on the approval of the change application. But if someone tries to sell the city 40 acres of irrigation that hasn't been used for the last 20 years, they're going to have a hard time getting that change application approved. But it's just the concept of change application, changing from nature of use. You can even change where that water is taken from, whether if it was originally taken from the American Fork River and now you want to take it from a well, which municipalities typically do. So you can have a change application on lots of different things. Yes, sir. Sorry, say that again.
That's based on a meridian, a wetlands designation. You can't change wetlands credits, is my understanding. There is not an exchange.
So your observation is you cannot change wetlands credits.
If I was taking water from Utah County and trying to put it out in Grantsville, it has to be within that wetlands mitigation area.
Well, I think, so we have some nomenclatures. I think maybe we have some semantics issues. So when I think of wetlands, I think of lands administered by the U.S. Army Corps of Engineers for duck habitat type of thing, right? Is that what you're talking about? Or are you talking about just the drainage, the hydrologic drainage?
There is both the hydraulic drainage. My understanding there's a hydraulic drainage and a wetlands issue when you transfer water from one area to the next.
So there's definitely a hydrologic, in order to change water, your example would never work, right? You can't change water from American Fork out to Grantsville because there's just no hydrologic connection between the two, right? You would be depleting more in Grantsville as a result of that. But you can move water from somewhere in American Fork to another place in American Fork because ultimately they both feed into Utah Lake. It's the same. Now, if you want to talk about wetlands and those types of issues, that's kind of beyond the realm of what we see from a division of water rights. Now, the U.S. Army Corps of Engineers could say you cannot move that water because that is part of these dedicated wetlands credits, so I'm going to protest your change application. But I think we're kind of getting into the proverbial weeds a little bit. So with regard to that, and I don't really have a lot of insight on how wetlands tie into change applications other than the Army Corps of Engineers can always protest a change application if there's some impact on wetlands. Did you have a question, sir?
Yeah, I did. So I got like 1.5 cubic feet a second
Okay.
for irrigation, okay? So, if you multiply that out, that's a lot of acre feet. So is there a method that they figure that? I mean, you can't go year round, so I don't know how they quite figure how much water you really have.
That's a great question. So he says I have 1.5 cubic feet per second water right. If you were to multiply that out 24/7, 365, that's a heck of a lot of water, right? How do you evaluate that? Well, in Utah, beneficial use is the basis, limit, and measure of a water right. You'll notice when I talk about water rights, I don't talk about how many CFS a water right. I talk about how many acres a water right is or how many houses a water right is because the beneficial use is the limit of the water right. So if you have a 1.5 second foot water right, it's going to be for 20 acres or 10 acres of irrigation. Then we look at the beneficial use and we say, that number of acres, let's make it easy, 10 acres of irrigation, using the duty value, and that's a concept you'll maybe need to become familiar with. A duty is, if you were to say, a column of water so many feet high, this is what alfalfa requires in 1 year. So in the Utah Valley, alfalfa requires 4 feet of water. So if you just an imaginary column, right? So that if you kind of do the equation, it's 4 acre-feet per acre. So if you have a 10-acre parcel, regardless of what the CFS amount is, we're going to say that 10 acres is worth 40 acre-feet, because that is how much beneficial use that alfalfa requires. And we use alfalfa because it's one of the most consumptive uses of irrigation. So even if you're using just Kentucky bluegrass or whatever, you still give you the benefit of the doubt. And that's also for just straight surface flow water, as though you were just spreading water out randomly rather than sprinkling, which is a lot more efficient. And so when you come and you say, I have this water right, we're going to look at the beneficial use and say, that water right is worth X amount based on the beneficial use, not necessarily on the CFS flow rate. Okay. Yeah, and we'd have to look in it. Sometimes you have these things called supplemental groups, which just make it even more complicated. But in that case, we'll just say, oh, you have 2 different supplemental groups, and one's for 50 acres, one's for 42 acres. So you have like 92 acres of irrigation. But I don't know if there are other water rights that are also supplying water to that 92 acres. So we'd have to look at the water right to kind of tell you what it's worth. So it's not as, that's why I'm saying it can be complicated. It's not always intuitive. We can help you figure that out, though. I'm going to go ahead and move to our website and just show you some features really quick. Again, feel free, if your curiosity has been satisfied, to make your way out. I first just want to show you our website. So this is the Division of Water Rights website, waterrights.utah.gov. We talked earlier about the public meeting where I'm going to post this presentation. First of all, you can go down to this training videos. You see my icon over here by the YouTube icon. This is where this will be recorded and posted tomorrow, okay? Or maybe the next day, depends on how quick Paul can do it. As far as the presentation, like the slideshow, if you wanted to go that, there's this tab up here called Meetings, and you'd go to Past Meetings, since tomorrow this meeting will be in the past, and you'll be able to find this meeting. You'll click on the link, and I'll have the PDF of the slideshow there, okay? Now, if you wanted to determine what water right, if you knew you had a well in your parcel, but you just didn't know what the water right number was, the best way to determine that is to go to our website and go to this little feature down here called Map Search, okay? So if I bring this up, click on the URL, it's going to bring up the whole state of Utah. And I'm just going to go ahead up here. On this list, there's a bunch of radio buttons that you can select or deselect. I'm going to deselect points of diversion because what you'll find is, as we kind of zoom in, it just becomes so crowded with points of diversion and it slows it down. So for the time being, I'm just going to turn that off. Also, what I'm going to turn on is this other layer called Adjudication Books, just so you can see where these subdivisions exist. And sometimes that takes a little time to populate, so I had the foresight of already doing it, okay, over here. And if you look at this, here's the subdivision we're talking about, right? Let's see if it decides to play ball. You can see American Fork City. I'm just going to go ahead and zoom in. You just take my word for it that this is the subdivision because it appears to be a slow connection. If you're not good at locating your parcel based on the aerial imagery, there's some tools. I'll show you how to search based on your address. But let's say you're pretty savvy at looking at stuff. You can kind of say, oh, there's Pioneer Crossing. Here's the Mill Pond. Here's Main Street of American Fork. And I live over here by the National Guard Armory, right? Is that National Guard? Yeah. Isn't that? Yeah, that's it. I used to drill there all the time. Okay, so if I go back and turn points of diversion on, let's see if I can get it to cooperate. I'm going to have to put it on my phone just because this connection appears to be really slow. I'm just going to connect to my hotspot really quick because it does not look like it wants to be very fast. So forgive the... All right, let's try to see if that does anything. Maybe there just aren't any wells. I guess there just aren't any wells over there. My bad. Okay, so let's take a look at these, all right? So you can see these little red icons with a well. That represents a point of diversion that we have on our records that's a well. The water right number is going to be the area code, which is 55, and then it's going to have like a 4 or 5 digit number after it, and that's the water right number. You can click on these icons, and it'll give you kind of a summary of the information. It shows the water right number up here. This is, an unapproved application, which I don't really care. Let's talk about this one. This one's an underground water claim, okay? And an underground water claim is one of those pre-statutory rights. You'll notice right here, the priority date is 1926, May of 1926. So this is drilled prior to 1935. Therefore, it's a pre-statutory right. We call underground pre-statutory rights underground water claims. Its owner on our records is Matt Blackhurst. And there's some other information. It has the type, it's underground. This is the location using the public land survey system, which says the north 2,055 feet, west 954 feet from the southeast corner of section 23, township 5 south, range 1 east. Again, if you don't know what that means, don't worry about it. We'll help you out. But if you select on the little water right link, it will take you to our database. And this will show you all the information we have on this water right. For instance, this shows what it's being used for. Well, let me scroll up a little bit to the top. Up here, you can see the name and address of the owner of record, Matt Blackhurst. That's his address. You can see what the water right flow rate is valued at, 0.223 CFS, or cubic feet per second. If we scroll down a little bit further, you can see the priority date right there, meaning that's when it was first established. And then we talk about, again, the point of diversion. That's the location. Already talked about that. But this is the beneficial use. So what is this water right used for? Well, it's used for irrigation of 5.25 acres. And it's used for stock watering of 3 ELUs, which is a term we call, it was an acronym, means equivalent livestock unit. So it's like a cow. So when you see ELU, think cow. And then we think, and then as a domestic beneficial use for 1 EDU. Again, that's the fancy acronym for 1 equivalent domestic unit, or 1 house. So you see EDU, think house. So house and cow. So essentially he's got 1 house, 3 cows on 5.25 acres that he's irrigating using this water right. And so if we wanted to try to quantify that, we know that a house is quantified at 0.45 acre feet per domestic unit. Stock watering is 0.028 acre feet per ELU, so that's a very minimal amount. And then irrigation in this area is 4 acre feet per acre, so it's going to be about 25 acre feet, or 21 acre feet worth of water, okay, plus the domestic. So it's going to be about, we'll just round up and say 22 acre feet is what this water right is worth, okay? So that's your best way of kind of figuring out. I'm going to show you now how to do a different type of search. If you come over to these tabs, there's lots of different tabs you can play around if you want to look at like what the quad map looked like or some other type of topographical map. but we're just going to keep it on aerial imagery, okay? You can go over here to search, and you can do a drop down. You can search by various things. If you know your water right number, that's what you would put in here. If you just know your address number, you go down to address, and this little box comes up. Anyone want to give me an address you want to use? Or no one wants to admit to anything? No one? Someone give me their address they're curious about.
4711 West,
What's that?
4711 West, State Road.
Is that the same as State Street or? Okay. They call it State Road though? Okay.
That's a county address.
That's all right. Maybe not.
1090 State Road.
Sometimes these state roads.
East, northwest.
Oh, is that what? So that's why I screwed up.
1090 East. Try that one.
Yeah, let's try that. And then we'll just. Usually it's not very picky about the city, but if you can get it close enough. So it's going to place an X where that address shows up at. And you can kind of zoom out and you can see.
Right there, that well right there. To the left, far left. See the left, far left of your map? Other side.
Over here?
Down. 806 right there.
Down here? Yeah. So that's how you can get close. If you're not very good at navigating a map, you can just add and enter your address and then it'll get you close. Okay. Are there any other features or any other questions you want? Oh, one thing I wanted to talk about. So on this water right, something that you might find interesting is if you go to this tab up here, it says Scan Documents. This is the file that we have. And you can see, you can sort it by date, which is I typically like to do. So down here, you have the actual claim when it was filed back in October of 1935. You can click on that, and it'll bring you up the scanned image of what that claim looked like, okay? So if you're interested about the historical documents associated with your respective water right, you can gain access to everything that we have down at the division. Okay. Is there any other questions or features you'd like to see? All right, well, I appreciate your time. Feel free to come on up if you have a specific question or talk to my staff in the back, and they'll help you answer it.
Thank you.
My pleasure. Thank you. No applause necessary. I get paid to do this.